In 2012, the SEC charged Paradigm Capital Management with front-running. The portfolio manager placed trades in the firm's proprietary account ahead of client orders, then sold after the client's large block trade moved the price. Clients got worse execution, the manager got the profits. That is a textbook standard VIB violation. By the end of this lesson, you will know every standard VI exam trap cold, prominent disclosure, front-running versus insider trading, and the referral fee timing rule that sinks candidates in every item set. Standard VI has 3 substandards, each with a distinct exam trap. VI A, disclosure of conflicts. You must disclose anything that could impair your independence. The trap, disclosure must be prominent. Footnotes are explicitly not sufficient. VIB, priority of transactions. Clients come first always. The trap, front-running is VIB, not Roman II-A, insider trading. VIC, referral fees. Disclose referral compensation to employer, clients, and prospects. The trap, timing. Disclosure must happen before the referral is made, not an onboarding paperwork that comes after. The exam tests exactly one thing about VI A, disclosure, the word prominent. Prominent means the disclosure must appear where a reasonable client will see it and understand it before making a decision. Wrong answer, a footnote at the bottom of the report. Also wrong, vague boilerplate that says the author may hold positions. Right answer, bold text on the first page, immediately following the recommendation. If a reasonable client could miss the disclosure while reading normally, it is not prominent, and VI A is violated. Here is the exact comparison the exam forces you to make. VI A versus standard IB. These 2 standards interact constantly, and candidates pick the wrong one. IB, independence and objectivity, is about maintaining your independence, your behavior. VI A, disclosure of conflicts, is about informing clients, your communication. The key, if the question is about a failure to disclose a conflict, the answer is VIA. If the question is about a recommendation that was actually biased by a conflict, that is IB. Both can be violated simultaneously on the same set of facts. Test yourself. An analyst writes a research report on a stock. Her employer is a market maker in that stock. She does not disclose this in the report. Which standard has she violated? The wrong answer most candidates pick is C, standard IB. IB would apply if her analysis was actually biased. The question asks about the failure to disclose. The correct answer is B, standard VI A. The employer's market-making role is a matter that could impair independence, and it must be prominently disclosed in the report. The exam tests exactly one thing about front-running, which standard it violates. Wrong answer, and the most common wrong answer, is standard Roman II-A, material non-public information. Here is why candidates get this wrong. Both involve trading on non-public information. They look the same on the surface. Here is the difference. Roman II-A is about material non-public information about a company, earnings, mergers, undisclosed events. Front-running is about knowledge of a pending client order. A client's buy order is not inside information about XYZ Corp's fundamentals. Front-running is always VIB, never Roman II-A. Engrave this distinction in memory. Standard VIB, priority of transactions, establishes a strict 3-level execution hierarchy. Level 1, clients come first. All client accounts execute first, including family member accounts managed by the member on behalf of the family member. Level 2, employer accounts second. Proprietary firm accounts execute only after all client orders are filled. Level 3, the member's personal account goes last. This includes any account where the member has a direct beneficial interest, joint accounts, dependent accounts, accounts where the member shares in gains. Pre-clearance approval does not change this order. Getting sign-off from compliance and then submitting your personal order before client orders is still a VIB violation. Here is the family account rule, the most misunderstood rule in all of standard VIB. Most candidates believe family accounts always go last. That is wrong, and it will cost exam points. The correct rule depends on two conditions. First, is the member managing the account on behalf of the family member? If yes, it is treated as a client account, equal priority, not lower. Second, does the member have a direct beneficial interest in the account, like a joint account or a dependents account the member controls? If yes, it is treated as the member's own account and goes last. Run the two-condition test on every family account question. Front-running question. An investment manager receives an order from client A to buy 100,000 shares of XYZ Corp. Before executing it, she buys 5,000 shares for her personal account, expecting the large client order to move the price. This is best described as a violation of which standard? The trap answer is a standard Roman II, A material non-public information. Client order information is not inside information about the company. The correct answer is B, standard VIB, priority of transactions. This is textbook front-running. The client order must execute first. Standard VIC, referral fees has one exam trap that appears in almost every ethics item set: timing. You must disclose referral fee arrangements before or at the moment you make the referral, not when the client signs the engagement agreement, not in onboarding paperwork, not in the first quarterly statement. Before the referral is made, that is the rule. And VIC requires disclosure to three separate parties: your employer, your current clients, and prospective clients. Disclosing to one does not satisfy the others. All three, and the timing requirement applies to each. Family account question. Marcus Webb manages a hedge fund. He also manages a discretionary account for his elderly mother, charging no fee. The fund gets a buy signal on stock ABC. Webb purchases ABC for his mother's account at the same time as hedge fund clients in the same batch order. Has Webb violated standard VIB? Most candidates say yes, family accounts go last. That is wrong. The correct answer is B, no violation. Family member accounts managed on behalf of the family member receive equal client priority. Webb is managing the account for his mother's benefit, not his own. Equal treatment in a batch order is not a violation. Family account question. Marcus Webb manages a hedge fund. He also manages a discretionary account for his elderly mother, charging no fee. The fund gets a buy signal on stock ABC. Webb purchases ABC for his mother's account at the same time as hedge fund clients in the same batch order. Has Webb violated standard VIB? Most candidates say yes, family accounts go last. That is wrong. The correct answer is B, no violation. Family member accounts managed on behalf of the family member receive equal client priority. Webb is managing the account for his mother's benefit, not his own. Equal treatment in a batch order is not a violation. Here is the exam day decision framework for standard VI. When you see a conflict scenario, run 3 questions in order. First, is there a disclosure failure? Someone failed to disclose a conflict, even a buried footnote, that is VI, A. Second, is there a trading priority issue? Personal trade before client order, IPO shares in personal account, tipping a third party about a pending order, that is VI, B. Third, is there a referral fee with no disclosure or wrong timing? That is VI, C. And check whether Roman 4, B is also triggered by the absence of written employer consent. VIC timing question. Sarah Chen refers her clients to a real estate firm and receives a $500 referral fee per client. She discloses this arrangement in standard client onboarding paperwork. A prospect asks for her real estate recommendation. Chen verbally recommends the real estate firm without disclosing the referral fee before the prospect signs any documents. Has Chen violated VI? C. The trap answer is as she discloses in onboarding paperwork, so she is covered. Wrong. The correct answer is C. Onboarding paperwork is signed after the recommendation. VI, C, requires disclosure before the recommendation. Timing is the entire issue. One scenario, two violations. This is how the compound violation appears on the exam. David Park is a sell-side analyst. His brother-in-law runs a financial planning firm and offers Park $200 for each client Park refers. Park agrees and discloses nothing to his employer, his clients, or prospects. The first instinct is to call this VI, C only, but the exam is looking for two standards. VI, C is violated because Park disclosed the referral arrangement to no one, not employer, not clients, not prospects. Standard Roman IV, B, additional compensation arrangements is also violated because Park accepted outside compensation from a competing firm without obtaining written employer consent first. Two standards, one scenario. Compound violation question. Same scenario, David Park, $200 per referral, disclosed nothing. Which standards has he most likely violated? Most candidates answer a VI, C only. That misses the second violation. The correct answer is B, VI, C, and Standard Roman IV-B. Roman IV-B requires written employer consent before accepting outside compensation from a competing firm. VI, C requires disclosure to employer, clients, and prospects. Two separate obligations, both unmet. Compound violation question. Same scenario, David Park, $200 per referral, disclosed nothing. Which standards has he most likely violated? Most candidates answer a VI, C only. That misses the second violation. The correct answer is B, VI, C, and Standard Roman IV-B. Roman IV-B requires written employer consent before accepting outside compensation from a competing firm. VI, C requires disclosure to employer, clients, and prospects. Two separate obligations, both unmet. Here is your complete standard VI cheat sheet. Lock these rules in before exam day. VI A. Disclose conflicts prominently. Footnotes are not prominent. Employer conflicts must be disclosed by the analyst, not delegated to compliance. Owning covered shares is not prohibited, it must be disclosed. VI B. Clients first. Front-running is VI B, not Roman II A. Family accounts managed for the family member equal client priority. Only direct beneficial interest sends you to the back. Preclearance does not change the execution order. VIC, 3 parties, 1 timing rule. Employer plus clients plus prospects. Disclose before the referral. Written employer consent also required under Roman IV-B. Three minutes on standard VI questions. Here is how to approach them efficiently on exam day. For any ethics question, read the last sentence of the stem first. Which standard has been violated or has the member violated? Then scan the facts for the key trigger words. Prominent or footnote, that is VI A. Traded before or ahead of, that is VI B. Front-running, never Roman II A. Referral fee, that is VI C, and check timing. If there is no employer consent mentioned, Roman IV-B is probably the second violation. The hardest standard VI questions are the ones that look like they violate a different standard. Trust the specific over the general. VI B beats Roman III A. VI A beats I B when the issue is non-disclosure, not bias.